a regular panelist and editor-in-chief of the New Crusading Guide, editor-in-chief at large, Abdul Malik Kweku Bako.
Thank you.
Also here in the studio is Bobby Banson. He's a lawyer. Your first time on Newsfile, I suppose.
Yes, that is.
Thank you very much.
Thanks for having me.
Good to have you. Ibrahim Murtala Mohammed, former MP and the Deputy Minister of Trade and Industry. Good morning and welcome to Newsfile.
Good morning, Samson.
Right. So this is familiar terrain for you too. Right. Okay. So on our very first issue, and the breaking news exclusive that we have for you is that the two parties in the SOFTtribe matter are having a resolution, hopefully on Monday, an emergency sitting which should resolve all the problems and get everybody back to work. But a lot has happened in the course of the week. Listen to Herman Chinrihese, chairman of SOFTtribe Limited. And after that, listen also to Clifford Brahima, managing director of the Ghana Water Company Limited.
They keep putting in the press like we are hungry and we need the contract. We are partners. We do work, they do work. They do the water, we do our IT. If they don't want to work with us, it is their right not to want to work with us. It is their right. I want to repeat this. It's their right. We are not fighting. This is not about contract. We don't want our intellectual property stolen. If we will fight to the death. We didn't go to school and work 20 years to invent something in hard Africa for some fool to steal it. That's not going to happen. That one we'll fight. We'll fight all the way. So I wanted to clear a few things. Firstly, our guy's phone that I said had been scrambled. A guy who they took in. They haven't returned the phone.
Okay.
But we found a remote way to access it and read what was on it. And we realized what they had done to it remotely. His phone has no evidence.
His phone in particular?
Exactly.
But which evidence do you suspect they were looking for on your phones?
The evidence of the extortion that we claimed.
The demands for extortion?
Yes. I'd like to also make a simple point. What in this raid that they came and did, couldn't they have just called, hello, yeah, we would like our data. 2-minute explanation. Oh, okay. Why did it require wasting state resources, bringing handcuffs and guns and so on? I mean, it's not even logical. Then I'd like to say this, that, you know, as I said, the best way forward, Ghana government has invested. We have invested. We think we've created a very good product, and the public is there, and they're using it, and they're happy, as far as we can see.
Once they themselves came to tell us that the system was being compromised, it's cause for alarm. Cause for alarm. We started experiencing the following challenges, actually, from that time. Balance on statement of accounts were different from water bills, making it difficult to handle customers' queries. Billing customers with wrong tariffs. 3 days ago, my minister was in Parliament, and I went to give her moral support. I met the MP for Mion. I'm mentioning this so that individuals can call them. MP for Mion in the northern region. Say, MD, I sent my mother to a house just 3 months. You brought me a bill of 10,000. Why? I said, oh, did you pay? He said, what will I do? Because they were threatening to disconnect it. Another lady called me. She's Laurata Musa Saka, at a point that she was credited 3,000 Ghana cedis on her bill. Instead of her paying us money, we rather owe her 3,000 Ghana cedis. Currently, myself and my deputy and the commercial chief manager, who is in Kumasi currently, but she has a rep here, are solving a problem of a gentleman, one Kwesi. What's the other name? Kweno. He lives at the plush estates around the palace. Is it West Hill? Airport Hills. Airport Hills, yes. He lives in Nigeria and USA. He comes to Ghana once in a while. And the bills they brought him over a period were so outrageous. So he's brought a complaint. And we are handling it to look at. They were even charging him commercial instead of domestic. Another one in Accra East, Roman Ridge. I tried to look for the bill. The man has had a swimming pool. He gets regular water. And the bill that comes to him is zero. And he sent a WhatsApp message to a friend who forwarded it back to me that our company is a company of jokers.
All right, so you heard the two gentlemen there, and Kuku, let me start with you briefly on what you know about the facts regarding this brouhaha. And good news, though, is that they seem to be getting to yes, not no.
You know his new nickname, Mr. No.
No.
Oh, okay, I see.
And I proudly like to wear that with Kwame Sefakai.
That's right.
Yeah. He told
Perhaps
the
I'll
speaker,
provide
he
you
told the
with this new
Speaker of
name.
Parliament on Friday that it has to be a no.
That's right.
But Kuku, let's. So I was saying that it looks like there's some glimmer of hope that now they want to go to this forum and then resolve issues and get back to business. But on the both sides, what are the facts as you know them, and do they justify the intervention of national security? And when you are done, Bobby can also look at that for us because of his background as a lawyer.
See, this whole thing was very untidy, avoidable. It lacked finesse. Needless negative publicity that is detrimental to the reputation of the company, SOFTtribe, the image of national security, and to some limited extent, the Ghana Water Company. You're telling us that there's a solution in the pipeline Monday.
Yes.
So they've struck a certain compromise. If they had all been sober, they had all been dispassionate, we would not be sitting here discussing this matter. They would have settled their issues on the quiet. Because even if it was a contractual dispute, I'm sure the contract that they signed on to will have provisions that show how to deal with the issue. I'm not aware if they exhausted all those things and then decided that let's go to town and make noise and counter noise. It's not right. See, national security architecture in recent times has come onto the front burner, sometimes for wrong reasons. If you cite the Ayawaso West Wagon incident and the proceedings of the Short Commission and the indication that there could be a certain disharmony relative to chain of command and all what has happened subsequent to that, does not need such incidents. They have to be, in a position to clean up some of the doubts and the discrepancies.
And this small bit that you mentioned, though important, you heard General Hesse suggest that they had made an attempt, or was the Bolton, one of the guys in the SOFTtribe, who said that they had, David Bolton, that they had made contact with the minister and discovered that nobody had given any such instructions for what was supposed to have happened, even though a person who was supposed to be leading and threatening them had been mentioning Brian Champong. And they discovered, after meeting with Brian Champong also, that the guy was setting the two of them up because he was unaware or something like that.
Well, I will not talk to specifics in terms of names, for good reason.
Okay.
But you see, the National Security Council Secretariat has a technical wing that is known as the National Bureau of Communications.
Right.
They've had some relationship with the company, SOFTtribe. And there's some understanding between the two sides because of the kind of job they all do.
And that's the team that did this operation?
Yes. But it is because of the kind of relationship they had or have that is why I thought this was needless.
Okay.
Straightforward. There was a rapport. There was a chain of line of communication. Everything was done. Somebody somewhere within national security architecture might have gotten too over enthusiastic and pulled the trigger, quote unquote. And that is what my worry is about. And I'm being very frank with you. You've mentioned names. It's for good reasons. I'm not going to mention names. I usually time what I say, when and where and how. But I think it's about time the president takes a look at the structure, in a way implicitly recommended by the Short Commission, in terms of the chain of command. Who does what, when, and where, and indeed how.
Did you say implicitly recommended by the Short Commission, or
I think it was explicitly
recommended by the Short Commission?
Okay. It was. I have, not that I agree with them in totality,
right,
in terms of the entire structure, no. I also have a little background. I'm a student of intelligence, not a professional anyway.
Okay.
But not that, but there was some element of validity, truth, in the observation, and for that matter, the recommendation that was made. And sitting somewhere under quiet and observing, it had merit. And I think this particular case, whilst I'm not going to go into details, I'm telling you this particular case is a reflection of that matter. You mentioned names. One day will come, we'll sit here and perhaps we'll put all the names out there. But I'm not too sure what you did, which appears to be cleaning up everybody there. If nobody did something, then who did what? I disagree. But as I'm saying, I assume it was a business gone wrong. The contract should have provided the avenue for them to tackle the issue.
And Chairman Hesse says that we are willing and we are ready. If you don't want the contract to continue anymore, we have 50%, you are also 50%, stakeholders. All you need is buy us out. Well, name your price and let's sit down.
Yes. You said that's a company that's a reputation that goes beyond the Ghanaian boundaries. I don't know them. I'm being honest with you, I don't know them. I know about them.
Right.
But I have no relationship with any of them or even with a company. But I've done some little checks in the last 2-3 days to realize that they go beyond Ghana, even Nigeria and the rest. So they have a reputation. And some of these things can affect their integrity and credibility.
When they started to make the giant steps, I remember long ago, it was Komla Dumont who introduced them to me, sort of, through the morning show.
Yes, so to be honest with you, I think that I'm even angry that we are being told that Monday they will be settling the issue. I'm angry. Oh. Because the
solution we should be looking for. So why are you angry that the basis for the
solution was already there. And they decided to go to town and mess up. And I would not blame the company for going to town if it did. They were provoked. They were pushed into a corner. And they came out talking. I heard the water company also talking.
Yeah.
I wasn't too convinced about what was being said from their anger. My problem is with national security.
But Brahima Clifford, the MD for Ghana Water, enumerated some problems that they have had over a period, even though the company says that this is like 0.1%,
those are part of the business thing that could be resolved looking at the business format you have. That's the point I'm making. Whatever those issues are, if the contract that they put in place was incapable of dealing with it, then I don't know what kind of contract they signed. The courts are there, arbitration, and all those things are there, available.
There's this other aspect. Do you think that also ought to be giving some serious attention? Because while Ghana Water is saying that there have been issues which we do not like, and that's why we are not happy about what is going on, and we saw that they were not allowing us to update our process, that's why we felt, data that is in the national interest was being protected. The company, SOFTtribe, is talking about one individual who was sort of the go-between, who was demanding money, and they had issues with that. That sounds clear criminal conduct.
That was the last point I made, and I was coming to that.
Okay.
After that, I'm not sure I'll make any comment. That I demand of SOFTtribe,
SOFTtribe.
a full disclosure. Whether it was out of provocation or anger or whatever, they put it out there. Once you've put it out there, it's registered in the public domain. Their compromise or their resolution on Monday would not exclude the demand for full disclosure as to who was engaged in this alleged extortion. So these two, they now have a certain line of responsibility. Perhaps next time you'll be sure what to say, how to say it, when to say it. But whatever it is out there. So we demand a full disclosure.
Mr. Hesse was very hedgy about that.
Then he shouldn't have spoken about it.
And what should be the purpose of the disclosure?
You just said criminal. You just alluded to something criminal. And what do we do to something criminal? We investigate. And beyond investigation, if there's prima facie, as you lawyers say, then we proceed to the appropriate forum to cure the mischief.
Okay.
Okay? That is important. Now let me make one last point, and I'm sure perhaps it has no legal foundation, what I'm going to say. But I feel that sometimes we should clean our Governance Act. This thing of going to court, ex parte, and collecting court orders, and then going out to enforce it. I think that relative to demonstration, the Public Order Act, the police conduct, it came up, so it became almost a subculture.
Right.
And I believe the courts even have cautioned the police that this ex parte route is not the best of things.
They have not only cautioned. When the Let My Vote Count Alliance went to the courts, the Justice Dennis Ajay, presiding as a Court of Appeal judge sitting in the High Court, gave a ruling that is now what they have to abide by.
Interesting.
They used to go to the lower courts, and they went there to take an ex parte, meaning they go on the blind side of the demonstrators or the organizers. And his ruling now is that, which is now sort of the law.
Binding now.
Yes, because that's higher up, above the lower courts.
Sure.
Is that first, you don't go to those lower courts. And second, you must come notifying the demonstrators or their organizers before you come. So that when you come to argue that they shouldn't demonstrate and you give all your reasons, they can also canvass their reasons why they should be allowed to demonstrate.
Yes, I would be grateful.
I think that's what has made it a bit difficult for them.
You give me a copy of that.
I will.
Please do.
I will.
But I hope, that's why I'm not sure if it has a legal foundation, that it could be replicated across and should have affected the Security Council.
I think maybe Bobby shall explain, but
Okay,
for security reasons, when there's a suspicion of a crime, the law gives power to the security agencies or police to go to the court. Once you are of the rank of a constable, go to the court and get an order to do something.
I'm better educated and better informed, but I really wish we clean up our Governance Act and let some equity inform some of these things we do. Bottom line, what happened was untidy, avoidable, lacks finesse, and negative publicity for all the parties involved, particularly the company and the national security outfit.
Okay. So, Bobby, and I wanted you to take it from the point of, from the facts that we have come to know so far from both sides. Is there a justification? What you people say?
You people.
Yes, you the lawyers say national security is sort of an octopus. Yeah, is there a justification for that intervention by the national security?
Good morning once again to your listeners and viewers, and thank you for having me once again. I associate myself largely with the comments by Mr. Kwekubako, except to add that it's very interesting how the national security decided to intervene in this matter from the legal perspective. I had the privilege of seeing snippets of the contract between SOFTtribe and the Ghana Water in the line of my professional work.
Okay.
I think about 2 or so years ago when this discussion started. And from what I recall, it was SOFTtribe that developed the software. It's an IT company that was going to now, they would now sold it to Ghana Water, not sold in terms of collecting money, but the idea. And what they were going to do was to implement and manage the system. Now, it seems from what has happened that, and particularly listening to the managing director of Ghana, they had issues with the revenue collection because it is SOFTtribe that collects the money and then accounts to Ghana Water. So Ghana Water believes that there's a discrepancy in the revenue that is generated and in the revenue that it's accounted to them. There is no way Ghana Water would be able to ascertain the authenticity of what is given to them unless they have access to the raw data. And for them, because it is in the possession of SOFTtribe, they had to use means of getting that data before they could even speak to the source of the discrepancy. You will recall that the managing director mentioned a few instances of complaints. So I'm sure for them, I'm playing the devil's advocate. It was an issue of, okay, so far we've heard about 10. What if there are 20 or 30 of such instances? And that will run, it may run into millions.
No,
of
but this is a
cedis.
software that has improved your revenue by 14%.
No, that is soft. I'm only playing the devil's advocate. That is SOFTtribe's contention. That, okay, maybe Ghana Water thinks that the revenue could have improved by 30%.
Okay.
And you are telling us because it is 14%, we should accept it as it is. So they may have been peeved, for lack of a better word, because of that scenario. Now, there was no way they could have had access to that data except to use extrajudicial processes. It is obvious. Because for them, the contract, I'm sure, had an arbitration clause. And it was going to be you'd have to file and then bring an application for full disclosure and all of that. It may have taken time for them. So they decided to now pull the trigger, as Mr. Barkon said, using this extrajudicial process. Now, looking at the legality of that whole scenario.
Why do you call it extrajudicial process?
Because that is where I'm coming to.
It's judicial.
No, I think it is extrajudicial.
Okay, so extrajudicial means?
Without recourse to the appropriate lay-down procedure in accordance with law.
Okay. Yeah, that's what I'm saying.
Does it mitigate?
That's what I'm saying.
So that is what I'm saying. That if they went to court,
extrajudicial means unlawful.
Yes, unlawful process.
Yes, but did they use an unlawful process?
No, I'm talking about the basis for them applying for that. The basis, the legal basis. Like you rightly pointed out, I believe it should be Section 8 or thereabout of the CPC, the Criminal Procedure Code, that gives the police service the right to take an application to the court for a search warrant.
It's Section 88.
88,
right.
Okay. Of the on the basis that they have a firm belief that the crime has been committed or it's about to be committed.
Right.
And evidence of the crime will be lost if the search order is not granted. So they have access to the premises. Now you ask yourself whether or not a contractual breach, as it were, would give rise to a criminal offense. That is where the aspect of national security allegedly or purportedly comes in. Because the order, the section that gives the foundation is for criminal matters. Now, this is a pure contract. If Ghana Water thinks that there's a breach, is that a basis for using the criminal procedure code to get that order?
So that we are clearer, let's read the provision which they would have used to go to the court.
Okay.
And you would know that before you even get to that provision, you must begin from Article 18(2)
of the Constitution,
which says that
right to privacy,
yes, and all of that. However, that right is curtailed once what is going to happen is to prevent crime or disorder and all of that. So here is what is happening. So before you get the warrant, it says a district magistrate who is satisfied, and they went to a district court like it's required, who is satisfied by evidence upon oath that there is reasonable ground for believing that there is in any building, vessel, carriage, box, receptacle, or place these things. A, anything upon or in respect of which any offense has been or is suspected to have been committed, for which according to any law for the time being in force, the offender may be arrested without a warrant. Or B, anything which there is reasonable ground for believing will afford evidence as to the commission of any offense, like you mentioned. Or C, anything which there is reasonable ground for believing is intended to be used for the purpose of committing an offense against the person for which, according to any law for the time being in force, the offender may be arrested without a warrant, may at any time issue a warrant under his hand, authorizing any constable to search any such building, vessel, carriage, box, receptacle, or place for any such thing, and to seize and carry it before the magistrate issuing the warrant or some other magistrate to be by him dealt with according to law.
Okay. And so before this order is granted, there must have been an application.
Right.
The application must have indicated in the affidavit the kind of offense that is being preferred against whoever the suspect is. I don't think we have seen the application they sent. And as of now, I don't think anybody from SOFTtribe has been charged yet, at least publicly.
Right.
We are not aware of that with any criminal offense. That is why I said that the basis for that application may not have been well founded, looking at the facts that is available to us.
But the magistrate granted it.
I mean,
even though SOFTtribe also have said that it was not signed and it was not stamped. There was no seal.
But
I
was
don't-
it stamped?
Okay.
I don't think
I think what they meant by a seal was a stamp.
a stamp, because normally the registrar signs it.
Right.
Sometimes they may not necessarily apply the stamp,
Right.
but the registrar signs it. The registrar of the court that grants it just signs
All right,
it.
so proceed.
It's not
Yeah.
a judge. The registrar signs it. Now, if they go for that application, most judges, and from experience, recently I was involved in a case like that, would grant the application because for them, the story that is sold to them, if you don't grant it and what we are seeking to prevent happens, then is we've done our part. You refuse to grant it. Right. So they will grant it for whoever is affected to now challenge it. Because SOFTtribe would have a recourse. For instance, their phones being seized, when I think justice was involved, Shrimsai, in a case where the human rights court said you cannot seize the phone without a court
warrant.
A warrant. So
and even after you seize it, you need permission to access it.
Exactly.
You know, sometimes they seize and they think that having seized it, they have a right to access the information on the phone.
And so that is why I challenge the basis. I've not seen the affidavit supporting the application.
Okay.
But if as of now, nobody from SOFTtribe has been charged with any criminal offense, then it seems to suggest that the whole application may have been an abuse of the court process.
Okay.
That is why I said that it seems to me they sat down and decided to use this, what I term extrajudicial process.
So can what Kweku was suggesting happen, that these things must also be on notice?
You know,
the don't go on the blind side of the other
Supreme
side.
Court has stated that ex parte applications are ipso facto an anomaly in our rules. And that until the rules specifically state that you are allowed to go ex parte, they do not think that any person should be allowed to get any ex parte. That is why ex parte rulings are time bound.
Yes.
So they give it to you, they tell you no more than 10 days,
Right.
you should execute it, so that it will not be a means by which people can abuse the process. Unfortunately, in this instance, they would have taken the order and executed the order. And your only recourse is to take the steps. If you set aside the order, if you bring an application to set aside the order, the application may be moot because it has already been carried
What
out.
Kweku is contemplating, is it practicable? Is this something we should think about?
I think it will be difficult to do it in criminal matters, in pure criminal matters.
Will it help the state in protecting us and the national interest?
That is why the Constitution states that whatever rights the Constitution gives you or you have as a human being is curtailed when it comes to matters of national interest.
Okay.
But the Supreme Court has the exclusive jurisdiction to determine in camera whether or not the circumstances are such that warrants the exercise of the state authority in the situation of a national interest situation. So in this case, assuming SOFTtribe decides to go to the Human Rights Court, that the human rights of the person whose phone was taken has been breached.
Those, not only one.
Oh, those, okay. And the defense by the Attorney General is that it was in the interest of natural justice. Then the Human Rights Court would have to stay proceedings.
Interest of national.
Sorry.
It was national
Security.
interest.
National security, sorry. Would have to stay proceedings, refer it to the Supreme Court, for the Supreme Court to listen to it in camera and deliver a ruling on that subject. I'm hoping SOFTtribe may. That's why when Mr. Baku said he's angry, I sort of sided with him because for us as lawyers, is if we don't have an opportunity to test the law to this extent.
Right.
So as it stands now, they say they want to meet on Monday to have a resolution. We would have to wait and see the outcome. But the optics, to borrow your term, does not look good at all.
Okay.
It does not look good at all.
All right. Yes, Mutala.
Well, something. I think that I largely agree with the two, contributors, even though I have a challenge with my senior comrade's inability to agree with you. When you mentioned specific names, he went ahead to talk about the fact that implicitly the challenges we have with the national security has everything to do with that particular name that you have mentioned, and the explicit, decision taken by the Short's committee on the issue.
You become my spokesperson.
He's become your interpreter.
Interpreter, rather.
He trained me, so I can understand. I think that is very clear. I don't know how long it will take the president to fire Mr. Brenner Champong. I don't know how long it's going to take the president to do that. If you are taxed with the responsibility.
You're talking in context, where they say this is the name mentioned and they make contact. They are told that they don't know anything about it.
Your own statement, you have indicated the man himself said that he wasn't aware of the action taken.
According to the SOFTtribe people who made the contact.
He is the head of that institution. And I'm saying that a senior comrade was talking about this, also juxtaposing, same with what happened with the Emil Short's committee and investigation and the issues that came up as a result of what happened. You have the responsibility.
But does the credibility of this person who was mentioning Brian's name matter? Well, after it was discovered that the same person was practically lying between SOFTtribe and Ghana Water Company, insisting that the MD doesn't make any direct contact
there is no
with SOFTtribe when he was doing the go-between and seeking allegedly to privately benefits.
There is no denying the fact that the operation was undertaken by national security operatives. So the issue as to whether the credibility of the person matter is neither here nor there. What matters is that an institution that he is the head can go and execute, projects, if you like, that he claims that he's unaware. And I think that Senior Comrade was juxtaposing this with other incidences that have happened. And mind you, we are talking about the national security.
Right.
Now, I have a little challenge with regards to some of the contributions made in the matter of getting this court order. The fact that the SOFTtribe people claimed that it wasn't signed, it wasn't sealed, whatever the interpretation is. We haven't heard any contrary view from the national security as to whether indeed there was a court order. You and I cannot. We are making our argument based on the fact that
national security will hardly reply.
I mean, clearly in matters like this for accountable and transparent governance, they need to. Okay. Because mind you, their integrity is being questioned.
Right.
That assuming without admitting that national security went there with a fake court order, I mean, that will speak volumes. Now, I want some education as to whether indeed the ruling that you said was given by the High Court, I guess.
Yes,
so.
yes.
Now, in the matter, Court of Appeal, in the matter of things like this, between national security and fundamental human rights of people at any point in time, which one take precedence? And I think for me, it's very important. Mind you, people's phones were actually seized. And in seizing those phones, they may gain access to information that those people, which are exclusively private to them, between that and national security. Now, if you give a carte blanche, that yes, national security, under the circumstances that they think that the security of the state, it at stake, they can do that, then we are all not safe. And I think perhaps we need a second look at that particular, permission.
The counter-argument may also hold, doesn't it? That your own security and safety is at risk if you don't give them a bit of that, you know, leverage.
The challenge is that when you have unabated incidences of such rights being abused.
So abuse, fear of abusing
yes.
the power given.
And mind you, the moment someone's privacy is invaded, there is no any redemption. Perhaps I have certain things in my phone I wouldn't want anybody to see. Then you've seen it. Is there any way by which it can be redeemed? Because you have indeed, you hid behind a right given to you as a state institution to execute a project. You have executed that, and my right would have been trampled upon. And that is why I said that maybe perhaps I need a bit of schooling in this matter. Which one do we, which one takes precedence? Is it about the national security? And the question is, if indeed we agree that even if national security wanted to do that, they could have informed, what's the name, the SOFTtribe. This is what we want to do. At the very time national security went to the court to make the argument and justify why they needed the order, these people could have gone alongside with them. So the court would have had the opportunity to listen to the two parties at the same time. And that is why I have a bit of worry.
But I was mentioning the
it will be risky, yes. Yeah. It will be risky.
You say it will be risky.
It will be risky
to wait
in such circumstances.
I'm not talking of waiting.
No,
I mean, it took time.
To give the suspect notice, because the whole idea of this Section 88 is to forestall the crime. Yeah. And so if you know that there's evidence within a particular premises, there is no way, I think, a superior court would rule that in those circumstances, such application should not be ex parte. That is why the affidavit in support of such application must be properly scrutinized by the judge.
I agree absolutely with you, but
it comes back to the question I was bringing to your attention also, that once you say because of fundamental human rights
and the consistent abuse of that particular...
Often what people also forget is that by Article 12, the fundamental human rights that you have to enjoy is subject to respect for other people's rights.
I agree.
So once you don't respect other people's rights, you lose the opportunity to claim that your right is being abused.
There are instances where this point you have made can be absolutely justified, where the security of the state is at stake. But we are looking at specific instances such as this, and many other instances that are similar to this, where necessarily it is not about the security of the state, where we have evidences that state institutions have abused this particular. And that is why I premise my statement, but perhaps I need some schooling. Perhaps a lot of, discussions ought to be done around this particular topic.
So public interest also trumps all of these.
Exactly.
So what do you think? ECG, GWCL, Ghana Water Company, is an essential service provider. Does that tell you right away that the questions of public interest and national interest will arise?
No, it will. There is no question at all about that. But here is the case. We have listened to SOFTtribe leadership. We have listened to Ghana Water Company. And now there is another serious matter on the issue of extortion.
Right.
And the video you played, the gentleman is alleging when your journalist asked him, what do you think they did with the phones? And he said categorically that they access information that borders on the extortion.
They were looking
for, exactly. I mean, they access information that bordered on the extortion. That is what they access, because they also found a way by which they could determine what they were looking for. Now, the question is that an allegation of extortion have been made. An allegation of extortion have been made against Ghana Water Company and perhaps national security. I'm saying that if
somebody who was the go-between
Ghana Water Company,
SOFTtribe and Ghana Water Company,
and perhaps with senior comrade position, it could even be from the national security, because they work in tandem with the national security. So I'm saying that if the gentleman is claiming that they have every reason to believe that the information they asked, and your journalist did a fantastic work, when he asked, what do you think they were looking for? He said he suspects they were looking for the
evidence
on the extortion. So is it a case that the entire raid occasioned not necessarily because a state interest was at risk, but because an individual interest which borders on extortion was at risk?
So that they were looking for the evidence to destroy.
To destroy.
Well, that's also speculative.
And I'm saying that it's possible, based on the evidences that have all been provided. So I think that we need thorough investigation. President Mahama issued a statement
on disclosure. Those who made the allegation should.
You must give the full details.
Exactly.
So we can
We will talk about that, but we also demand that further investigation ought to be done in this matter. And you yourself, you have said
And the
that
further
it doesn't
investigation-
matter. It doesn't matter the sitting.
If you can wind up in a
It
minute
doesn't
for
matter
me,
the meeting they are going to
move
hold
on to
on.
the next
We
issue.
said it doesn't matter the meeting they are going to hold
Yeah,
on Monday.
it's a matter
that
of
it
principle.
doesn't insulate.
Of course.
The investigation to extort, because that is criminal.
Okay.
The issue of extortion is criminal. Assuming that that was the purpose for this Rambo-style reckless, invasion of the premises of SOFTtribe. And I think that it is
investigations will not be held if there is no disclosure
All right.
of who was engaged.
But we'll get the disclosure through the investigation. We'll get the disclosure. We'll get the disclosure through the investigation by appropriate state institutions.
Thank you very much. You want to say something?
Yes, I was just thinking that the Section 38 is the power vested in the police. I mean, is the police.
Right.
Now, I don't know the coordination that went on between the police and the officers who actually undertook the raid.
The police, there's a police attachment to
To
national
the
security.
okay, fine.
So
Then
sometimes,
secondly, you asked the question about Ghana Water, whether the issue is a matter that could be of public interest nature. I think the individuals who may have been affected by this alleged maybe revenue miscalculation in terms of the consumers who were complaining, they have a recourse to sue Ghana Water individually. And if they sue Ghana Water, the agreement between Ghana Water and SOFTtribe definitely would have an indemnity clause.
Okay.
And so it need not necessarily have been escalated to the public interest or national security level.
Okay.
Like Uncle Kweku said, that there would have been dispute resolution clauses within the contract.
Thank you very much.
Just 30 seconds.
Yes, quickly.
The excuses given by Mr. Dr. Clifford justifying the raid that the national security, and he made references to complaints by clients or those they provide the services to. Every single, even in his office, I believe that they would have had some challenges. So the fact that you have challenges in a system, is it a justification enough for you to say that we need to abrogate the contract that we have with you? Or to, I think that if Ghana
that's
Water,
a decision
if
for
Ghana
them to
Water,
make.
no, if Ghana Water Company argues on the basis of the refusal of SOFTtribe to allow them to have access to back up their data, for me, that makes a lot of sense than making references to 2-3 people who have complained.
So I'll share a few messages with you. We'll take a break and then we'll return to look at the Auditor General and the NDC's claim that he's being witch-hunted, so to speak, sort of affirming what the CSOs have sought to say. Nchibwe Siako says, how can Ghanaians tell a genuine national security operative on approved assignment from an imposter with a fake ID? What are the distinct features of a national security staff ID or badge? And what number can citizens call to verify the ID of a person who claims to work for national security? I'll return to share a couple more of these messages with you as we deal with the next matter of the Auditor General, Daniel Domelevo.